Okay, ladies and gentlemen, let me welcome you at my panel or our panel about the role of the prosecutor in prosecuting environmental crime. As you already know, my name is Michalovič and I'm from Comenius University, and I will be leading this panel. But first of all, let me thank you to my panelists who are also prepared beautiful articles that were very helpful, and it really helped me to prepare this presentation. So I'd like to thank you, give thanks to Kristina, thank you very much, and from Hungary, from Czechia, Miss Katarzyna Weissová, thank you very much. Also from Poland, thank you, Marcin, for your article. And also I would like to thank my lovely wife, Denisa Michalovič, who was actually the main leader of the article we wrote together. So, she's writing, I'm speaking. That's the deal. Finally, I can say something publicly. Okay, let's get to the topic. I would be briefing, or I would introduce the topic and what I found in those 4 articles. So what's the context of the environmental crimes and the role of the prosecutor in this area? So to state obvious, I would say the environmental crime still remains one of the most under-prosecuted areas of criminal law in Europe, or especially in V4 countries, I would say. Also, the prosecutor's office plays a decisive role in this area, and especially in ensuring legality, coherence, and effectiveness of enforcement. And my presentation should, or that's the idea of it, provides a comparative overview of prosecutorial structures, procedures, challenges in all V4 countries. And my aim would be to identify the shared pattern, distinctive national practices, and potential paths for harmonization within the EU framework. So I would like to begin with institutional framework, which was actually a little bit eye-opening for me, because despite the fact that all V4 countries have, I would say, multi-level institutional network, I was actually surprised by how many levels have the other countries compared to Slovakia. To start with Hungary, you can see they have 4 tiers of prosecution offices, starting with the office of the Prosecutor General, going through Appellate Chief Prosecution Office, County Chief Prosecution Office, all the way to the District Prosecution Office. And I wanted to ask you, if I make some mistake, please correct me right away.
You're perfect.
Yeah. And I would like to add that environmental and nature protection departments operate within the criminal law division. When we look at the Czechia or Czech Republic, they also have 4 tiers, starting with Prosecutor's General Office, then 2 high public prosecutors' office, from which one of them you are from, as I know. Awesome. And then going through the regional public prosecutors' offices and district public prosecutor offices. I would like to add in Czech Republic that specialized prosecutors for environmental and economic crimes operates in the system, and also the system applies very strictly or heavily the dominus litis principle. When we look at Poland, they also have 4 tiers, starting with National Public Prosecution Office. And one of the most surprising things for me in regards to Poland is that the Minister of Justice is also the General Prosecutor in Poland, which is strange for us, or very different compared to other countries. And I would like to add that environmental cases handled by specialized teams in cooperation with Forest Guard and other administrative bodies. In Slovakia, now we have only the 3 tiers: the General Prosecution Office in Bratislava, then regional prosecution offices and district prosecution offices in general. I would like to add one specific piece of information that within the police force of Slovakia, we have a special department called the Department for Detection of Hazardous Materials and Environmental Crime, so-called Enviropolis or Enviropolicia in Slovakia. Let's continue with the initiation and pretrial proceedings. In all V4 countries, the prosecutors may initiate or supervise the commencement of proceedings for environmental crime. In Hungary, the police actually conduct the investigations, but prosecutors maintain broad supervisory power and may also act in civil and administrative matters that are related to environmental damage. In Czechia, as I already mentioned, the prosecutor acts as a dominus litis, meaning that he can directly supervise the police using, and I would like to also add that diversion tools as conditional discontinuance or plea bargains are used commonly often in environmental cases. In Poland, at least the article provided information that it's more oriented on cooperation, meaning that administrative bodies, for example, forest guard or border guard, often act as investigators, which is different compared to our systems, while the prosecutor provides only a supervision, or not only, but supervision in general. And they also stated that there is a limited use of mediation or summary proceedings, which is rather common, for example, for Slovakia, where prosecutors also serve as a dominus litis, also in work or also in home. And they oversee the pretrial proceedings led by specialized environmental crime police officers with authority to intervene or take over the whole investigation, which is actually happening rather in 0.001% of cases. But they can. Across all V4 countries, discontinuities and delays remain frequent, meaning mainly due to the evidentiary challenges, expert dependence, and low detectability of this type of environmental crime. When we are talking about the sentencing practices, all V4 countries rely or rarely result in custodial sentences. Which was very surprising for me. The main outcome of the criminal proceeding is mainly suspended imprisonment or fines in general. And in Hungary, environmental crimes are generally sanctioned by fines or imprisonment, but most times it is only suspended imprisonment. Most often suspended, as I mentioned. A recent trend aims to increase corporate fines as a percentage of company turnover, which is already in line with a new directive on environmental crime. And confiscation and asset recovery measures are applied with growing frequency. So they're starting to apply it more and more in recent years. In Czechia, the legal framework provides a broad sentencing toolbox, including bans on activities, forfeiture of profits, and publication of judgments. However, the statutory minimums remain low, especially in waste-related offenses. But I believe that's going to change as well due to the new directive. In Poland, the situation seems the courts tends to impose exceptionally lenient sentencing. So the suspended prison sentences and small fines are the main outcome, even in serious cases like waste mishandling or air pollution cases. And in Slovakia, I learned from my wife that although the confiscation and other property measures exist, they are inconsistently applied, and prosecutors know that sanctions often fail to correspond to the actual environmental damage. I also put together the list of major challenges relating to prosecuting environmental cases. I got 6 of them, so bear with me, please. So there is a heavy dependence on expert opinions and absence of unified methodology for environmental damage assessment. And especially in Slovakia, you appoint some expert, for example, in area of waste management, and you literally wait a year or year and a half to get the expert opinions. And you have more questions. It's taking even more time, so it's pretty time consuming. Another major challenge is that there is an overlap between administrative and criminal liability. This one is very specific and very huge problem in Slovakia. It's not evident which unlawful conduct should be punished by administrative law, which should be punished by the criminal law. So there is a lot of inconsistencies in classification, and there is a lot of procedural stagnation, or on the other side, there is ping-ponging from administrative body to police and prosecutors back to the administrative body and stuff like that. There's also a problem with limited admissibility of administrative evidence gathered by inspection bodies in pre-trial process. There is also, which is very common, or I would say characteristic feature of environmental crimes, which is low detectability and delayed reporting of offenses, especially in waste and air pollution cases. There is insufficient coordination and data exchange between prosecution, police, and environmental inspectorate, except for Poland. We will get to it because that was my question, because it seems it's working in Poland. So that's the thing we wanted to hear and wanted to learn how to do it maybe better. And there is a shortage of specialized experts, prosecutors outside of major urban centers. And the thing I already mentioned is lenient sentencing in these cases. So in order to get to my findings or cross-country differences, in Hungary, prosecutor possess mixed competencies. They act in criminal, civil, and administrative law. Corporate fines are evolving towards turnover-based sanction, which is pretty awesome, I would say. Environmental cases increasingly involve cross-border dimension and complex expert evidences, and as I understand it, they're trying to evolve or build up on this cooperation between states. In Czechia, there is a strong application of the dominus litis principle, where the prosecutors lead investigation and direct police action, which also applies to Slovakia. There is a rich use of diversion tools, such as conditional discounts and plea bargains. An institutional framework is highly centralized but hindered by fragmented data and limited statistics. That applies to Slovakia as well, unfortunately. In Poland, there is evidence gathering often led by the administrative body. There is high degree of interagency coordination, but on the other hand, there's limited admissibility of administrative evidence in court. And sentencings remain exceptionally lenient, which actually reduce deterrence of punishing people. In Slovakia, I would say there is a specific feature, which is existence of special environmental crime unit, and we also use especially designed and trained environmental prosecutors. There's a frequent referrals between administrative and criminal proceeding, and also there is a use of confiscation tools that are available, but they're rarely used, unfortunately. Just to briefly get back to the environmental crime directive, in the future, all of our countries will need to transpose this directive in very near future. Actually, I believe the deadline is in April or May next year. So this directive actually introduces a couple of new criminal offenses, such as forestry, trade in forestry commodities or unlawful water abstraction, and something for Vojto, illegal ship recycling. That's your topic, right? And all V4 systems will have to enhance capacity, data collection, in interagency coordination, and between the states cooperation. And its implementation actually offers an opportunity to bridge administrative and criminal enforcement and ensure more coherent and effective protection of environment. So just to summarize it, the key messages of this presentation, of this analysis, would be that environmental prosecution in all countries remain formally robust but functionally constrained by limited resources, expertise, and data. Prosecutors are often reactive rather than strategic, with environmental cases initiated mainly by external complaints or inspections. The administrative criminal interface is both a challenge and an opportunity, where the cooperation mechanisms exist, but evidentiary integration remains incomplete. Sanctions are too lenient to ensure deterrence. Turnover-based corporate fines and systematic confiscation should become the standard and should be part of the practice more often. And the new directive will create a common path for harmonization and capacity building across the region. So, to conclude, the future progress depends mainly, at least from my from my point of view, on strengthening specialization and expert support with prosecution services, establishing joint databases and reporting systems, and promoting restorative and preventive dimensions of environmental justice. So I believe the discussion should focus on how prosecutors can transform from enforcers into strategic actors in environmental protection. Thank you for your attention.
Thank you for these corrections that can make me possible to be more correct or put the emphasis on the relevant facts. Through your eyes, I can see my article in a better way. So maybe I was not the most accurate in any aspect. You mentioned that I should correct if I find something. So first of all, not only the criminal field or criminal field prosecutor deals with environmental cases, because in Hungary, there are authority in the hand of the prosecutor to deal with civil and administrative law field measures either. That means initiations, for example, to initiate a proceeding and so on. And so the second question, to your second question, the answer is that this more than 40% increase is comes from the measures from the civil and administrative law field, prosecutorial measures. So, and if I just put some slides to follow my that is that. So. And the other measure I put on the table just to be able to follow that how large numbers can be mentioned about the criminal offenses. But the criminal offenses have another side, because through administrative and civil law proceedings, we can find some evidence to know about the facts or prove that some crimes happened or some crimes were committed. So the other emphasis I will put in my article in a better way, that there is a strong cooperation between the different divisions. I think in Hungary it's a good existing, good working system. And for example, you can imagine if you can have decisions of the authority. For example, environmental authorities, environmental bodies send their decisions to the prosecutor, and the prosecutor can have the facts, but the facts only laid in the decisions. So that's the difference, that we can say that there aren't so many proofs of these kind of environmental cases. And if, in my opinion, the best way is a comprehensive way. We know that environmental cases cannot really treated just from one section or just from one field of law. So these are the numbers. I don't want to bore anybody with these, but stricter criminal measures can be found. As Sylvia, who was here in the latest division, mentioned that there are stricter and stricter criminal assessment of conducts. There are new criminal offenses, for example, in our penal code. And there are new criminal behaviors, or, for example, I put it there. Yes, from the 20th of August this year, we have abuse related to the trade in pets, for example. That is a very common crime. Okay, and it's just so this slide is just for not speaking so long. So the brief speech is the good speech, as János Edeszilágyi professor mentioned last night. So I put the new ordering investigations, and from this you can find some tendencies at how many cases we have to deal with. And not in many cases are enough burden, enough proof, enough evidence. So you asked for this kind of active repentance that can be just like you see in the criminal code, that liability to punishment shall be terminated by active repentance. And this means, for example, in damaging the environment, that the perpetrator shall not be liable to punishment in the cases, and his punishment may be reduced without limitation in the case specified in the para 1, if he averts the danger of environmental damage caused by criminal offenses. So it's not an often form. As you can see, it's another with full of numbers. But if you want to check it, and this will be my last slide, if you can see that conditional suspension by the prosecutor, that means that the process ends in the hand of the prosecutor, is this kind of number that are two-digit numbers, and maybe we can see from these kind of tables that it's not so easy to deal with these kind of crimes without comprehensive approach. And last one, okay, I don't want to read this because I don't want to use my time. It's not my time, it's yours. So my main problem is the nebis in idem principle. That means that you cannot have double jeopardy. You cannot have double assessment of cases of behaviors. That makes our work more difficult, because there are proceedings that are suspended because of, for example, a criminal procedure. And, for example, administrative fines cannot be operated in these cases. And from the last year, the Constitutional Court said that in civil law cases, either is the same situation. We cannot handle criminal conducts in civil law cases. A prosecutor can file a lawsuit in civil law cases, but there isn't any this year because it was prohibited because of this nebis in idem principle. So I have a question. What do you do with this kind of principle? Thank you.
Thank you. So good afternoon, ladies and gentlemen. I would also like to thank you for having me here. And I will start with 3 quick remarks to what has been already said. with respect to the Czech Republic, I have to say that the thing that we most lack as prosecutors is a specialized police body like they have in Slovakia. The thing that we appreciate most is the cooperation with other law enforcement bodies, which we have since like 5-6 years in various working groups and so on. And I can also answer the question of the Hungarian colleague, because we usually discuss the questions of nebis in idem with other law enforcement authorities on the highest level in particular cases, so that we actually divide the violations into the categories that will be prosecuted and that will not be prosecuted, that remain for the administrative bodies to deal with, which is quite good. And I think you all know the decision of the European Court of Human Rights, AB versus Norway, which is a good point of referral for me and for other prosecutors to know where the borders are. So that's for this. And the last remark, I think the biggest challenge we are facing now is the transposition of the European of the new directive. So not only with respect to the new law, to the new legal provisions that we will have in our criminal codes, but also with respect to the know-how, because the prosecutors have to know what they are going to prosecute according to the new transposed crimes. So, and to these questions, the first question, the answer is quite clear and will be quite brief, because there are not many powers that the prosecutors or even the judges have with respect to make the perpetrator pay or reinstate the environment, because the criminal code, the criminal procedural code, doesn't give us much opportunity. I pointed out in my article that by this conditional discontinuing of the proceedings, the prosecutor has the opportunity to bargain with the perpetrator that a certain amount of money has to be paid for a special fund for victims. But it was also mentioned here today earlier that environmental crime is typically a victimless crime. So this is a kind of paradox. And we tried within the new environmental crime directive to persuade the legislators that it would be nice if those money from the environmental crime, from the perpetrators, could go to the special environmental fund we have in the Czech Republic, but they are not very keen about this, so it's not in the new amendment proposal. But this would be nice from the perspective of the sentencing that should be dissuasive, and also so the perpetrators would see, okay, I violated the law, there was a damage to the environment, and now I have to pay into this fund that can also put money into reinstatement of the damage to the environment. So that's for the first question. And for the second one, that's quite complicated. So I will try to do what I can in the time I have. This is so we will have from the 1st of January 2026 as prosecutors opportunity to discontinue proceedings on the grounds of not having sufficient evidence to bring the perpetrator before court. The explanatory note states that this is broadening the elements of opportunity. I'm not quite sure about that, but it's said so. And from a certain point of view, it can be, because there is really no public interest in filing an indictment against a person that you from the very beginning know that you will fail to, or the court you cannot prosecute and the court will acquit. So the explanatory note also states that this is also made for the sake of saving state money that are paid to the defendants that are acquitted. From my point of view, it's a good tool for prosecutors in that minimum of cases that you already know in the pretrial proceedings that you don't have enough evidence. So until now, we had to file an indictment in those cases based on some probability that the defendant is the perpetrator of this case, even if he didn't have enough evidence. So I'm not sure if this will be the case for in many, if this will happen in many environmental cases. We already use quite widely the ultima ratio principle. So it might be, but it also might not. This will show the future. Thank you.
Thank you very much for the invitation. I'm very glad to be here. It's a great honor for me, an opportunity to be able to speak during this conference. First, I'm going to, because I do not have the presentation, but already I'm going to highlight one of the main differences. Because, for example, you mentioned, which is for sure correct, that environmental cases are one of the most under-prosecuted cases in V4. And when I was preparing my article, because I'm a not prosecutor, unfortunately I'm not, I asked the general prosecution that please give me any data you can have, basically, to say very basic, And they said, okay, but I received it when I already submitted the article. So, but it turned out that a lot of what I wrote is very similar or almost the same what they think. But a few numbers, because you said that in your countries, the numbers of cases is increasingly very high. And I asked about that, give me the statistics, and this is what they said. To be honest, as it was mentioned before, especially in Poland, we have this kind of a problem because some of the regulations regarding the criminal responsibility, when it comes to the substantive criminal law aspects, are regulated in criminal code, but some of them are outside in other laws. That's the problem. So I asked them, can you give me kind of statistical overview about, is there an increase of those cases for prosecution? How big is it, to see the progress, how it's comparing, how it progresses? And what is very surprising, what was, at least for me, very surprising. I'm not going to speak long about the numbers, but shortly. First, we have the introduction phase, and when the proceeding was introduction. So in 2020, we had 862 cases. In 2021, we had 932, so it is increase. But then in 2022, we had 919, so it's decrease. In 2024, we had 937, almost the same, not skyrocketing, completely different by you. But then, when it comes to the indictment, when it was already applied, that's even more surprising. Because in 2020, we had 151. This is only for the from Article 181 to 188, so only from criminal code, not above it, not beyond it. So in 2020, we had 151. In 2021, we had 179. But, for example, in 2024, 128, which is down, not up. This is surprising, but this is what the numbers are telling, completely different to you. But you may say that if the numbers are like this, then maybe it is a discontinuation of proceedings. So that this should be going up. What are the numbers are telling? This is the result. In 2020, we had 737. In 2021, 789. In 2023, 927. But in 2024, 873. So again, down, not up. So this is very surprising, but this is the case. I mean, for me, it's a huge difference, especially comparing to the numbers you showed us. Now, to the questions. For sure, for Poland, what is important is that there is this comparison between administrative forces and the prosecution. And what is the case? What they told me is that because we have an act on the Environmental Protection Inspectorate, when the General Inspectorate of Environmental Protection is regulated, and it was in force from 1991. So it is a long story. But what the prosecution said to me, it was even more surprising. So they said to me this, that relatively short periods since the new provisions entered into force from 1991, they told that this is a short period. The relatively short period means that this cooperation should be developed gradually. So for them, even though it's many years already into force, they think that this is a short amount. At present, they told me that the General Inspectorate of Environmental Protection should do only specific investigative tasks requiring specialist environmental knowledge. For example, sampling or on-site inspections or preparing expert analysis. So that means that for them, this General Inspectorate should do very, very specified tasks only if it's regulated in this period. The second question, very briefly, because the time is going out, regarding the general clauses. This is very important because we have things like insignificant amount or a large amount, and here in Poland it is even mixed. Because, for example, in Article 183, this meaning significant amount was erased. It is no longer in that article. But in Article 181, it is still there. So it depends on article. In one of the article, one of the offense, there is those kind of things like this general clauses. In other ones, it was changed and erased. And what the general prosecutor said, that when they erased it, it simplified the procedure. Because now they do not have to think, is this amount enough or is it not enough? How high it should be? For them, it is not a question now. But the problem is that they erased those clauses in some articles, while in some other, they're still there. Why? I do not know. But this is the other topic for another discussion. Thank you very much for your attention.
So thank you very much. I'm glad to be here. So I will tell you something about the prosecutor and his role in environmental criminal cases in Slovakia. So the dominant position of the prosecutor, like dominus litis, in environmental criminal cases manifest primarily through the active management of the interpretrial stage, including directing the police investigation, issuing binding instruction on evidence gathering, reviewing the legality of procedural actions, and coordinating expert and technical evidence, which are crucial in these cases. Specifically, the prosecutor supervises and directs the investigation, ensuring that the police follow the law and that all necessary evidence to clarify the act and identify the offender is properly obtained.
Next, the prosecutor issue binding instruction to the police, for example, to conduct background checks, identify company executives, or question witnesses. Next, the prosecutor evaluated the evidence, particularly expert opinions in fields such as ecology, some chemistry or forestry, which are often complex and essential for preventing environmental harm. In summary, the prosecutor dominant role, like dominus litis, in environmental crime case is reflected in the central authority over the investigation, evidence assessment, and procedural legality, ensuring that the process is both efficient and lawful. I will tell you some case example about the illegal waste dump in Nitra. Nitra is Slovak city, big city, and it was in 2021 year. 2021 year, please. 21. In 2021, authorities uncovered a large illegal landfill of construction and municipal waste on the outskirts at Nitra in the city. The waste had been continuously deposited on farmland without any authorization. The investigation was initiated following a report by an environmental NGO, which warned of the leakage of hazardous substances into the soil and groundwater. The role of the prosecutor in this case, like dominus litis, was that the prosecutor immediately ordered the initiation of criminal prosecution for the offense of unlawful waste management, according section 302 at the Slovak Criminal Code. Next, the prosecutor in this case issued binding instruction to the police to collect soil samples, question the cooperative's management, and identify the company responsible for the waste transport. Next, the prosecutor directed expert forensics examination in chemistry and environmental science, which confirmed contamination of the soil by heavy metals. And in the end, the prosecutor, after the evidentiary process was complete, the prosecutor filed an indictment against the company's director and ordered the freezing of the company's bank accounts to the secure funds for environmental remediation. So this a little about prosecution in environmental crime. So thank you very much.